attorney with the Dallas Volunteer Attorney Program. As we celebrate November as National Adoption Awareness Month, we are fortunate once again to have Jenny Womack as our speaker on adoption. Jenny has helped create many happy families since she began practicing law in 1998. A passion she exudes in her practice, which is limited to adoption, surrogacy, gaming donation, and family building. Jenny's education is from the University of Texas School of Law. She graduated with a JD with honors. She's quite accomplished, numerous publications, presentations, professional associations, and awards in Texas and nationally. She is currently the president-elect of the Academy of Adoption and Assisted Reproduction Attorneys. She has been recognized in Texas Monthly as a rising star and named as a super lawyer. She has been our speaker on termination adoptions for about 5 years, I think. And she has also been a pro bono volunteer, taking more challenging termination of parental rights cases. And she also finds time to mentor our pro bono attorneys individually on their particular cases. Please join me in welcoming Jenny Womack.
Thank you, Catherine. I appreciate that. So just a couple of little housekeeping things. I will be doing questions at the end because of how this is set up. I won't be able to see them once I start sharing my screen. But you should actually, at the bottom of your screen, there should be a Q&A and you can put the question there. And I will come back to that at the end when I am through. So I'm going to go ahead and share my screen now. Give me just a second to get that going. And today we are going to talk about, termination and adoption basics. So I have been, just to give you a little bit more baseline, I have been doing adoptions since 2001. I think that's right. So for 19 years, so I've been doing this a while. There are a number of different statutes. Most of you probably know that adoption is primarily state law driven. So we're going to look at our family code, chapter 162 on adoptions, 161 termination. 152 is, of course, the UCCJEA, which is about jurisdiction for those who are maybe not as familiar with family law and family code. And then there's some other things in chapters 102, like standing, and 107 covers things like the amicus, attorney, and home studies and all of that. So we'll hit all of those as we go. There's really two steps to an adoption. The first is terminating parental rights, and the second is the final adoption. These can be done separately, but they can also be combined into a single suit. Now, most of my practice, not all, but most, is newborn adoptions. And in those cases, because the child is supposed to be in the home for 6 months before final adoption, I'm going to separate termination from adoption. But when I am doing situations where the child's been in the home, a lot of times this is going to be relative placements, step-parent adoptions, things like that, where the child's been in the home for some time. I would combine them into a single suit, and we will talk a little bit about that as we go through this. Jurisdiction, of course, everybody probably remembers this from law school, but you need personal jurisdiction and subject matter jurisdiction. Personal jurisdiction can be waived, and it's not fatal if you're lacking it, but subject matter jurisdiction can't be waived. And if you don't have subject matter jurisdiction, your order is void, not voidable, void, as in no good. And that could cause a lot of problems, particularly in an adoption. So you need to make sure that you are complying with UCCJEA. Again, most of my cases are newborns. They were born in Texas. So this is their home state. I don't usually have to worry about a court of continuing jurisdiction because, again, newborns. But if you are doing step-parent adoptions, older children, you do need to look into this. Some of you may be saying, but UCCJEA doesn't apply to adoptions. That is true. UCCJEA does not apply to adoptions, but it does apply to terminations. So if you are still terminating parental rights, you definitely need to worry about court of continuing jurisdiction. The main thing is usually home state jurisdiction for most cases. That's where they've lived for at least 6 months, or for a child under 6 months since birth, which is, of course, why my newborn cases, I have jurisdiction here in Texas. Standing, this is again in chapter 102, but of course, Texas Department of Family Protective Services or any licensed child placing agency. I represent a couple of those. It can be someone designated in an unrevoked relinquishment. Again, that's what a lot of my private cases are. Step parent, an adoptive parent of a sibling, an adult who's had possession for a certain period of time, so on and so forth. Most cases I do are in that probably top 3 categories. Interstate compact. So when you do have a case where not everyone is in Texas, baby's born in Texas and the adoptive parents live in New Mexico. I've got one of those right now. There is a compact, interstate compact. It's adopted by all 50 states that requires approval of both the sending state and the receiving state before the child can leave the state. So in my cases with the newborns, before that newborn can go home with the adoptive parents to New Mexico or wherever, you got to have approval from both states. There are limited exceptions for step parents, grandparents, aunt and uncle, I think also adult sibling, if I'm not mistaken, but very, very limited. So if it's the aunt or uncle of the birth parent, that's not close enough. You still have to comply with ICPC. I recently had that situation. And they had an attorney who told them they didn't have to comply. And I said, oh, yes, you do. You aren't the child's uncle. You are the birth parent's uncle. It is mandatory. You do have to file an affidavit stating whether you've complied or that it doesn't apply with every termination suit or adoption suit. And there is an organization of the ICPC administrators that has promulgated this Regulation 12 to give guidance on what should be included in the ICPC packet. My recommendation is if you end up with an ICPC case and you're not familiar with it, contact a lawyer who is, and certainly contact a lawyer in the other state as well. That's one of the first things I do when I get retained on an ICPC and interstate case is I talk to an attorney in the other state that I know is experienced to make sure, because some states don't follow Regulation 12 very closely and decide they want extra things. Couple of warnings. You want to be careful of an international adoption. This is actually pretty common in, I don't know if it's true in every state, but certainly I run across these a fair amount, where the child is not a US citizen. If the child is not a US citizen, even if the child is here with proper documentation, it may still technically be an international adoption. International, if it is an international adoption, in the truest sense of that word, it does require that all adoption service providers be accredited, whether it's involving Hague countries or not. There's a lot of complications. Also, obviously includes immigration issues and things. You want to be very careful. You don't just do a domestic adoption, you know, oh, birth parents are willing to sign off. We can do it all here. Child's been here long enough. You can probably do the adoption, but the problem is you may then not be able to get the child's citizenship later, and that child could get deported. So you need to be very, very careful if the child is not a US citizen to explore this and make sure you are protecting that child's right and immigration status. You also need to be careful of secondary placements. This doesn't come up very often for me, but it has. If the child has been previously adopted, there are some restrictions. These came out, I think, about 2 legislative sessions ago, where if you're handling such cases, you could have criminal liability. You either have to have an agency involved, or you have to have a court order before custody changes. So you've got to be very careful with that. And one final thing that I always warn potential clients about, potential adoptive parents about, is in Texas, you cannot provide financial assistance to an expectant mother except through an agency. The only thing, otherwise it's a felony. It would be a felony to pay it. It would be a felony to receive it. I actually had to have that conversation with somebody this morning. So that is definitely something else to be wary of. I think this will come up again as we go a little bit further. So let's talk about the first step, termination of parental rights. You can terminate rights voluntarily or involuntarily. Most of my cases are voluntary. or at least with regard to the mother. There will be voluntary relinquishments. The birth mother signs what's called an affidavit of relinquishment. There are a lot of requirements, but some of the biggest is it has to be signed at least 48 hours after birth. That varies obviously by state. Has to have 2 witnesses and a notary. If it is signed to an agency, whether it's to TDFPS or a private agency, it can be irrevocable as long as it states that. If it is signed directly to the adoptive parents in a direct placement, then it's either has to be revocable for 10 days and becomes irrevocable on day 11, or you can provide that it's irrevocable for 60 days. I used to use that back when I could get terminations done in 60 days. Now it takes longer for most cases, so I use the 10-day revocable, and you just have to wait until the 11th day for it to become irrevocable. Indian Child Welfare Act, and I think I may have some more on this a little bit later, but if the child is an Indian child, which means the child is a member of the tribe, or the child is eligible and their parent is a registered member of the tribe, you've got to comply with the Indian Child Welfare Act, which is a totally different situation. That can't be signed until at least 10 days after birth, has to be done in open court. It's revocable until rights are terminated. There's a whole lot to that. And I think, like I said, we'll talk about that a little bit more later. You cannot put conditions in an affidavit of relinquishment. So you can't include things about like visitation, any kind of condition cannot be conditioned. It is unconditional. Texas does not have open adoption in a legally enforceable sense. Do they happen? Yes, but they are all honorary. You no longer, for those who've been practicing a while, you may remember affidavits of status. That was where you had to name the birth father. We are no longer required to do that, which also means that the birth mother is no longer required to name the alleged father. There are some kind of caveats to that we'll cover in a little bit, but in general, she would not have to name the birth father unless he is a presumed father. A presumed father or an acknowledged father, and for those who don't know, presumed father is usually a husband or somebody that she's divorced within 300 days of the birth. An acknowledged father is someone that he and the mother signed an acknowledgement of paternity regarding the child. So could also be somebody, an adjudicated father, who they've already got a court order saying he's the father. But if you've got one of those, you need to have them sign an affidavit of relinquishment, same restrictions as birth mothers, 48 hours post-birth, so on and so forth. In the event that he is not the biological father, and I end up with a fair number of these where mother's married and he is not the biological father, you still have to terminate his rights. And so ideally, you still would want an affidavit of relinquishment. With an alleged father, who is basically anybody who's not a presumed, acknowledged, or adjudicated father, he would sign an affidavit of waiver of interest. These can be signed anytime, even before birth. Similar formalities, but it's irrevocable even in private adoptions. So not just agency cases, they're irrevocable when they're signed. It does not have to include an admission of paternity. And in fact, I've drafted them where it specifically says, I understand that mom has named me as the father, but I absolutely deny paternity of this child. I've had them do that in a waiver before because they did not want to admit it. I think because a lot of them are afraid this will be used against them to establish their paternity, but actually by statute, it cannot be used for that purpose. But if you aren't voluntarily terminating, you've got to come up with grounds for involuntary termination. There is a very long list, and I'm sorry, I know this references an exhibit because in the past I've had printed handouts, but of course, since we're not together, we don't have a printed handout, but they are listed in 161.001. And there's a long list. There's abandonment, there's abuse, there's neglect, non-payment of support, long list. For alleged fathers, we also have a paternity registry so that if there is a child under the age of 1 and he fails to register with the paternity registry, you can terminate his rights based on that failure without notice. I will caution you, do not name him in your pleadings, even if you know his name, if you're going to rely on paternity registry, because there is some conflicting case law out there about whether or not you have to serve him if you name him. Now, you can't, of course, use any other grounds without serving him, but failure to register with paternity registry, you can use, again, if the child is under the age of 1. If the child is over the age of 1, you have to do due diligence to identify and locate him first. But if it's still one of these situations where the birth mom says, well, his name was John, and that's all I know. Obviously, if that's all you have, you can't find John. That's not possible. So you would be able to use it for that. I have had this crop up with an older child one time that the mother was deceased and the family had no idea who the father was. And so we did rely on paternity registry in that particular scenario. I would also consider, even if you have an alleged father signing off on a waiver or presumed father signing off on a waiver or whatever, I would consider terminating any potential unknown, unnamed, or unidentified fathers based on using the paternity, failing to register, because it's not unusual for mom to be mistaken about who the father is. I've, in fact, had 2 cases where that happened. And fortunately, because we did terminate any potential unknown, unnamed, or unidentified fathers, we knew that the father wasn't going to be able to come back later on. You do have to prove clear and convincing evidence. You have to prove your grounds by clear and convincing evidence. And whether you're doing voluntary or involuntary, you have to have the child's best interest finding. Always, always, always. So in your termination and adoption petition, you want to include any grounds that you can. Again, except if you're using the failure to register with the paternity registry and you're not going to serve the alleged father, you can't use other grounds against him without serving him. You need to allege best interest, attach your relevant documents. The caption should only have the child's initials and should have that little line at the top about document contains sensitive data. Normally, I file these after at least the mother has signed her relinquishment. There are ways to potentially file pre-birth or even before relinquishment if you've got the standing, but most of the time I don't file till after I at least have mother's relinquishment. Whether you have to serve anybody or not really kind of depends on the facts of your case. Certainly, any presumed, acknowledged, adjudicated father who doesn't sign a relinquishment would have to be served. An alleged dad, particularly of an older child, where you can't rely on the paternity registry, you're going to need to serve. And if you have to do it by citation by publication, of course, you have to do your due diligence, file that with the court, get your court order. You now also have to post, if you are doing citation by publication, on the public information internet website. That's actually what it's called. In fact, I just had a case where I'm having to do that, and it was apparently the first one the juvenile courts had. So it's been fun and a learning curve for everybody. You do have to have an adoption evaluation done in every adoption, including step parents. It needs to be filed in the termination suit as well if it's not an agency adoption. So if it's a direct placement private adoption, you need to file the adoption, or a lot of times you hear it called the home study. You need to file that in the termination suit as well as in the adoption. I've had clients or people ask me about, well, can you waive it for step parents? And I will tell you, yes, I've heard that there are judges out there that do that, but the statute says that they shall order it, that there shall, and that you shall file it. So I don't think that they can waive it. Under surrogacy, there's a provision in our surrogacy law that does allow a court to waive a home study. There isn't one under our adoption laws. So I do not believe a court can waive that. And I don't think they should, quite frankly. I think that opens them up to some liability should something happen. Normally, you would have a pre-placement evaluation, and then you would also have post-placement, particularly in agency adoptions. But if you've got a situation where the child is already living in the home when you file your lawsuit, you can combine those. This is like your step parent cases, a lot of those relative cases where child's been in the home for some time. you can just do a combined report. When you go to trial, or hopefully a prove up if everything is either voluntary or default, you can just do a simple prove up. Make sure that you've requested any amicus or ad items that you need. If you're doing a default, you need your service member's affidavit. If you've done publication, you need certificate of last known address, and you need statement of evidence. All of those little formalities still apply even in adoption. If it's contested, it can be to the bench, or to a jury. A lot of my colleagues in other states are just amazed that termination of parental rights cases can be to a jury. I'm like, oh, this is Texas. You can get a jury for anything here. And you are entitled to a preferential setting upon request. I've never done that, but I do know a couple of colleagues who during COVID have actually pulled that card because they were told that they could not get a hearing until sometime in 2021. And remember, you've got to have best interest of the child. Always, always, always. Termination, adoption, voluntary, involuntary. You must have best interest of the child. Your order needs to, of course, include that finding. It needs to include a finding about continuing jurisdiction, either that you've searched the Bureau of Vital Statistics as required, or that you don't have to because nobody's contested it. That's what my order says, because nobody ever contests that issue. On my cases, again, newborns, or I know it's the court of continuing jurisdiction. If you haven't combined it with an adoption, you're going to be appointing a permanent managing conservator. You don't have to specify the rights, but I do, including the right to consent to the adoption. You do not have to send the birth parents a copy, has a 30-day appeal period, does have some expedited appeal issues. And if it's based on voluntary relinquishments, including that affidavit of waiver of interest, it can't be attacked after 6 months. And even within that 6 months can only be attacked under fraud, coercion, or duress. I put a question mark next to seal the record because there are some cases where you may not want to seal the record, but I will tell you, at least in Dallas County, all terminations and adoptions are automatically sealed. Amicus attorneys. So when you're talking about private cases not involving CPS, involving the department, it is discretionary whether or not the court wants to appoint an amicus attorney to represent the child's best interests. This is kind of a similar role to a guardian ad litem in CPS cases, for those familiar with CPS cases. But it also has some similar duties to an attorney ad litem, in that if the child's over the age of 4 or older, you do have to interview them, things like that. But again, you aren't bound in this case by the child's expressed objectives because your focus is on the best interest. I will tell you, in Dallas County, the juvenile court judges always appoint an amicus in private adoption termination cases. At George Allen in the family courts, it is pretty fact specific whether or not they want one. Most of the time they do, but every so often you might not need one. If you've got a situation where you are working on a CPS case, in that case, that's when you would have a guardian ad litem. It's not a guardian ad litem in a private case. Only in TDFPS cases would it be a guardian ad litem. In the private cases, that's the amicus attorney. It's a mandatory appointment in CPS cases. And if guardian ad litem is an attorney, they have to serve in a dual role as attorney ad litem as well, unless you end up in a conflict between expressed interest of the child and best interest. And then you can potentially ask the court to appoint a separate guardian ad litem for the child. There's a lot more about this in the family code, but I know I want to make sure I have time for questions. So I'm going to kind of speed through a little of this. You may need an attorney ad litem for parents. Certainly if you're doing publication, you need to have an attorney ad litem for anyone served by publication. They have to check your due diligence, so on and so forth. If you've got an indigent parent, in CPS cases, it's mandatory that an attorney ad litem be appointed. In private cases, it is discretionary. I have had to appoint an attorney ad litem for an indigent parent in a private termination case that was contested. The court can also appoint an attorney ad litem for an alleged father if you're doing paternity registry. It's mandatory in CPS cases, but it's pretty rare. I've actually never had a judge do that in any of my cases when I'm using paternity registry. They might if it were a child that was older, but again, majority of my cases are newborns. If you are an attorney ad litem and you're representing the alleged father, be sure you also check the paternity registry to make sure there's a paternity, or check that a certificate is on file. You don't have to personally check it if the attorney for the petitioner has done so, which they should have. So let's talk a little bit about the adoption step. So we've already talked about the fact it can be combined with a termination suit. Again, I usually would only do that if the child's already been in the home for 6 months or so close to 6 months that by the time we actually get to this, we will have hit that 6-month mark. The 6 months can be waived, that 6-month residency requirement can be waived for good cause. But I would be very cautious about doing this. It's not uncommon for a judge to waive a week or two pretty easily, particularly as you approach the end of the year. It's not uncommon for me to do a number of cases in December that maybe should have waited till January, but the judge will let us do it so we can get it done by the end of the year. Or if you've got really good cause, I had a case where the adoptive parents were with the State Department and being stationed overseas and needed to finalize the adoption in order to get their orders and passport and everything for the child to be included. Again, the UCCJEA does not apply to adoptions. So if you're filing that separately, you can go back to the prior court where termination was done. Pretty much any court that's done the termination is more than happy to take on the adoption as well. Or you can file in the county where the child or the petitioners reside. That is a section in Chapter 103 of the Family Code. I'm sorry, I don't have the exact section cited for you. So prerequisites to the adoption. If the petitioner is married, their spouse must join. And I've had a case where this caused a problem because I had a spouse who could not get approved on a home study. And so we could not do it as an adoption. If the petitioner is not a managing conservator of the child, then you also have to have written consent of the managing conservator. Obviously, this is except in a step-parent case, but of course, then usually you're going to have the parent who's the managing conservator as a petitioner. This happens mostly in agency or CPS cases where you've got to have the agency or CPS give the consent. If the child is 12 or older, they also have to consent to the adoption. In writing or in open court, I usually have them do both. I have them consent in writing, which I file, and then I also have them testify at the prove up for the adoption. And the petitioner and the child should appear. If the child is 12 or older, they're technically required to appear. This can be waived. Right now, of course, you probably all know these hearings are all happening by video. So it's a little bit easier now for people to do this, but I do have interstate cases where my clients live out of state, and so one of them would come back for the hearing, whereas the other one and the child would maybe remain at home because that was considered unduly difficult to fly with a 6-month-old. And certainly, you know, an argument can be made that it's in the child's best interest that they not be flown back to Texas for a 5-minute hearing. Required documents for the final adoption. You do have to have your ICPC affidavit. You are supposed to require, in theory, a UCCJEA affidavit if you've got a party from out of state. I will say, I think in an adoption, not necessarily do you have to file that, but certainly in terminations you do. In the adoption, you do need to file the termination order if that's a separate action, or if a parent's deceased, a copy of the death certificate. You need to file your adoption evaluation. If they've got a pre-placement and post-placement reports, you file all of it. If they have a combined report, it's obviously just the one report. You have to have a health, social, education, genetic history report, except for close relatives. And this is going back to that step-parent, grandparent, aunt and uncle, adult sibling scenario. Criminal clearances on the adoptive parents that are dated within 12 months. This can sometimes be a problem in that depending on when their home study was done, their criminal clearances might be more than a year old. So you might need to have those updated. So you want to make sure you check on that in advance. And again, if you need, consider managing conservator of the child, like we've talked about. So in your order for the adoption, you need to include findings that all of the requirements have been met. Be very specific. I have separate paragraphs for every single requirement. You have to state the adoption is in the best interest of the child. And if you've combined your adoption and termination, you need to have separate best interest findings. You need a best interest on the termination and a best interest on the adoption, 2 separate findings. I usually have them even completely separated because I'll have termination in the first part of the order and adoption in the second part of the order. So they're usually in very separate areas. You want to have separate findings. And of course, it can include a name change. If you aren't going to change the name, which is usually more in like a relative type adoption situation. Though occasionally I will have private adoptions where they gave the baby the name the adoptive parents wanted from the beginning. I just put in that the name is confirmed. So that's very clear. I didn't forget and leave out the name change. They aren't changing the name. And then of course you can seal the record. I will tell you in Dallas County, it will be sealed whether you want it to be or not. Amending the birth certificate. This is where sometimes people have a lot of trouble, particularly out-of-state attorneys will have a lot of trouble on this. And so just so you know, talk a little bit about this. You need a certificate of adoption form. You can get this from Vital Statistics website. You can also email me anytime you want with any questions. I'm happy to help. That will then get certified by the clerk after your adoption is done. For those in Dallas County, if you're doing this at George Allen, you can actually take that to the clerk of the court, so up on the 3rd or 4th floor, and they can certify the certificate of adoption for you once the adoption is completed. If you're over at the juvenile courthouse, where most adoptions I do happen, the records clerk Marilyn over there will certify that for you. If the child is born in Texas, you also need the birth certificate mail-in application form. That's also available on Vital Statistics website. I absolutely would expedite the process. It costs an extra $13 plus the cost of overnighting or FedExing to Austin. Otherwise, it's going to take much longer. Expedited takes about 4 months. And yes, that is 4 months. But if you don't expedite, it's taking at least 6. And I know a few attorneys out of state who have been waiting on them for about a year. So it can be quite a mess. That application form is signed by the adoptive parents. They have to do it in front of a notary. You include a copy of their photo ID with the application and the certificate of adoption form. If the child is not born in Texas, then you're going to want to check, obviously, with that state to see what they require. Usually I just check with their Vital Statistics office. Most of them, you can find that information online. If not, then I contact an attorney I'll know in that state. Because through the academy, I do know attorneys in almost every state of the country. I still send the certificate of adoption. I also send a certified copy of the adoption decree, and then whatever other forms and of course fees that they may require. So that is the end of my slideshow. So I'm going to stop sharing that and go to questions and answers. I know I went through that very fast, so please feel free to add more questions. So interstate compact, the first question I had was about interstate compact. So what type of approval is required? I don't know quite how to answer that, but it is, when you do interstate compact, there is a long list of documents you have to file. One of those is also a cover sheet called a 100A. And on that, that is either signed by the birth mom, if it's a direct placement to the adoptive parents, or it's signed by the adoption agency. And that all goes first to the sending state. So let's say baby's born in Texas, it will all go down to Austin, to the ICPC office in Austin. When they approve it, they will then send it to the receiving state. When they approve it, they end up all signing off on that 100A. And then usually what happens is while you do get that written version, you will get a verbal approval beforehand. The 100A is a standardized form. I think it's also on Vital Statistics website. I know I just have it on my system, so, but I'm pretty sure it's available on Vital Statistics. But if you're doing an ICPC case, I would absolutely recommend that you, if you've never done one before, that you co-counsel with someone who has. I'm always happy to help out with that. In fact, recently I helped a very good friend of mine with one who had just not done an ICPC and was like, okay, what do I do? I was like, I can help you out. But you have to include things like, you have to include like the birth mother's relinquishment, birth father's relinquishment, or a legal risk statement, copy of the home study, copy of the criminal clearances. If it's a newborn, discharge from the hospital, if it's an older child, current medical records. There's just a lot of things that go into this packet, and it does vary a little by state still. There are some states that do require some extra things. So hopefully that answers your question, but you do ultimately get written approval from the ICPC through that 100A, but you will also get verbal. So what typically happens is that I will either get a phone call or an email from the Texas ICPC administrator telling me my clients have been approved and that they can go ahead and go home. And then I let my clients know. And then usually a week or two later, I will get a copy of the signed 100A in the mail. So hopefully that answers that question. Let's see here. What about the pre-order adoption? What something that you can come to the judge saying you want to adopt a child who lives overseas? Is there something like that? So for the person who asked about this, if you're talking about adopting a child who lives overseas, that is an international adoption. That's a whole nother level. It is not something that the judge here approves in advance. You have to go through USCIS for approval. And usually you would do the adoption. Most countries, you do the adoption overseas. There are a few exceptions to this that don't actually do adoptions. But you would adopt overseas and then you would come home with the child. Child would automatically be a citizen under the Child Citizenship Act of 2000. I think that's right. And then you can recognize the adoption here, but you don't, there's no I don't think there is a pre-order adoption. If somebody's wanting to adopt from overseas, then either they're going to be working with an agency who operates in that country and is accredited and so on and so forth, or if they've identified a specific child, they would need to talk with somebody to find out if it's even a possibility, because it isn't always a possibility. I had a client one time who had identified a child in a country that will not let Americans adopt. So I had to tell them that it was not an option, but it's not something that a judge here approves in advance. The judge here would see it after the child has come back and either was adopted in the foreign country or in those countries that only give a guardianship, which there are a number of Muslim countries for the most part will only give guardianship. Then they come back here and that's essentially equivalent to termination and permanent managed conservatorship, and they do the final adoption here. Hopefully that answered that question. But if not, please feel free to contact me later and we can talk more about specifically what you're looking at. Excuse me while I scan through these. Who notifies biological fathers of the existence of the paternity registry and how to register? It's up to them to figure that out. There is, I mean, it's not actually very hard to find, but I think it's Lair v. Robertson case, and don't quote me on that, but it basically says you're presumed to know if you had sex with somebody, you're presumed to know you could have fathered a child, and therefore you need to do something about it, which is why paternity registries have been upheld all across the country. Not every state has them. I think there's about 30 some odd states that do, if I remember right. And I will say, if you've got a child, if you're doing a termination in Texas and you're going to rely on paternity registry, if that child was not conceived in Texas, you not only have to check Texas's paternity registry, You also have to check the paternity registry in the state of conception if they have one. Again, not every state does, but a lot do. But it is not up to us to notify them. They are, ignorance of the law is not an excuse. We all know that. That's one of those things I hammer into you. If I ever had an adoptee client who wants legal assistance in finding birth parents and navigating privacy issues. So I have been contacted by various people. Sometimes it's an adult adoptee, sometimes it is like a spouse of a deceased adult adoptee or a child of an adult adoptee, an adult child of an adult adoptee, who are wanting to potentially research into that. If they don't know where their adoption occurred, a lot of times there's not much I can do to help them. If they know what agency they were adopted through, particularly some of the older ones will know. I usually recommend that they start there. There are services out there I know that can help with this. But it's very rare that I can do very much for them if they don't know where they were adopted. I can sometimes help them if all they're trying to do is unseal a record to get some information. I can help with that. But it's not an easy thing to do, and not an area that I've really expanded my practice into, because there aren't a lot of people doing it trying to do it through me, for one thing. And there are services out there that can probably do it better and faster than I can. Yeah. Oh, look, hi, Alicia. What is the best way to learn more about adoptions to be able to volunteer and take a DVAP case? Well, I'm sure Catherine and Maricela could tell you more about this, but I would just say take a DVAP case, and if you need help, they can help guide you, or if you need more, they can send you to me. I'm always happy to kind of help with that. A lot of times what will happen is I'll end up taking on the amicus job as pro bono and sort of mentoring through my role as the amicus. That's happened on several cases through DVAP. So hopefully that answers that question. Sorry, my phone is ringing. So can we get a combined termination and adoption petition? Well, I don't share my forms, so I don't have that. I don't know if DVAP has a combined form that they share on their cases. I will tell you, my form basically takes everything from my termination petition, everything from my adoption petition, and basically stacks them, and anything that overlaps just goes up at the front, like referencing ICPC affidavits, things like that. And then I do all the stuff on the termination and then all the stuff on the adoption. So it's basically, I literally just combined them. And I am very sorry, my computer is doing something weird. Do I file my home study report with a petition? So I do file the adoption evaluation or home study. Usually I do file that as an exhibit to my petition. However, if you have to get a court order for it, like if you're using family court services or going to use a home study provider that is not an agency, and therefore probably will need a court order approving them to do it, obviously you have to file your petition first in order to get that court order. Most of my cases either involve an agency, or in my private cases, I refer them to agencies to do the home study so that they can do the home study in advance, and I do file it with a petition. But if you're going to do something where you need a court order, and again, that would be family court services, which pretty much I think all DVAP cases go through them, you're going to have to file your petition first. Okay. What is the process and time frame for obtaining copies of the signed order? Oh yeah. So process and time frame for obtaining copies of the order after the file has been sealed. So right now, with everything being the way it is, you back when we were doing prove-ups in person, you would just take copies over to the clerk and have them certify and conform and certify them for you right then. But now, since we're doing everything online or through video like this. The orders are getting signed. At George Allen, you have to get copies from the records department, but because it's sealed, you have to get the judge to sign off on an order to unseal. The records department actually has a form that you can fill out. I just did this last week, which is how I know all of this. They have a form that you can fill out. I was able to get the associate judge who was there that day signing orders to sign. I had 3 cases I was trying to get copies on. She signed them. I took them back down to records. They gave me my copies. Time frame on that, it really depends on the court, how quickly the court signs it. Most of the judges I'm finding are signing same day or maybe a day or 2 later. If you are doing an adoption over at the juvenile court over on Lone Star with the 304th or 305th, you actually, as the attorney of record, can go to the records clerk, Marilyn, and get your certified copies from her without having to unseal the file. As the attorney of record, you can do that. Timing on that, again, it depends on when the judge signs it. Usually, at least with the 305th, the coordinator often will email me back a conformed copy of the order so that I know it's been signed, and then I just contact the records clerk and request that she make some certified copies, and I go pick them up and pay for them, because you do have to pay for all of this. Not in DVAP cases, I suppose, but you might need to talk with Catherine. Catherine and I were talking a little bit about that earlier, about how that might work. And then I think that's pretty much, but the time frame, it just depends. I know in the 304th, the judge is usually there about once or twice a week to sign orders. So it just kind of depends on how quickly the judge signs it. But once the judge has signed it, you can pretty much go to the courthouse and get copies fairly quickly. How do you contact me? So you can, the best way to contact me right now is my email, which is Jenny, Jenny, at WOMACadoptions.com. So WOMACADOPTIONS.com. And I'm also, I can also type that in here. I don't know if everybody's going to see it, but if you're looking at the chat or at the questions, you might be able to see where I'm typing that in for you right now. If you, for some reason, don't have it, didn't catch that, please, so you can contact DVAP. They have my email as well. Do I handle adoptions in Tarrant County? I actually do not. Are there nuances? Yes. That is why I don't do them over in Tarrant County. If you've got, oh, hi, Nikki. I was like, oh, wait, I recognize that name. If you've got questions in Tarrant County, I would recommend contacting an attorney over there named Eric Freeby, Freeby, or his associate, Alyssa, whose last name, I apologize. She got married and I can never remember which is her last name and which was her married name and which was her maiden name. But they can probably tell you adoptions over there. And I don't know how it's going now with Zoom, but there are a few nuances over there. And so I no longer go to Tarrant County because of that, and because I've been hometown once too often over there. Okay. What if a child is from a foreign country and has lived here over 6 months with their aunt and uncle? Can the child be adopted with their aunt and uncle? So if the child is not a U.S. citizen, even if they came here properly, and even if they are still properly documented, or maybe their visa has expired, probably if they've been here 6 months on a visitor visa, it's expired. That is probably an international adoption. Now, you might, if you've got grounds to do SIJS, and I've done a couple of these in the last couple of years, and I've got one going right now, where you might be able to do SIJS and then get the child their LPR, their legal permanent residency, then we did the adoption. So I don't want to say that can they be adopted? I'm not going to say no, they can't, but you have to be very, very careful that if you just do the adoption without considering all the immigration aspects, that child might be barred from getting U.S. citizenship. And that is going to be a nightmare you don't want to handle. So I would definitely get a lot more facts about that scenario. And then bring in an immigration attorney who also understands adoption, not just any immigration